everyone. Welcome to another exciting and educative episode of the Edfields Podcast. I'm Davina Sarah Bidi, your host for today, and our panel today constitutes Albert Ekokwenu, Eunice Edu Bosman, and Prince Benson Mankotam.
Today you've mentioned my full name.
So, in one of our episodes, we discussed land acquisition and its related matters. Today, we are discussing another pertinent topic to the ordinary Ghanaian, rent wahala, and what the law says about landlords and tenants and their relationship. We all know that about 50% of the Ghanaian citizen enters into a rent relationship with their landlord and tenant. At least each person will be a landlord on the one part or a tenant on the other part.
Yeah.
Our discussion today is about the agreements between the landlord and the tenant and their obligations and other related matters. So as part of our rights to own property, the owner of the property or the land may give his property to someone to occupy it. This means that the person giving out the land will reach an agreement with the person who is obtaining the land. This agreement is what normally governs the rent agreement or the tenancy agreement between the parties. So can our panel tell us about the agreement, what it's legally called, and the components of this agreement?
Well, rent is something when I got to a point I referred to myself as a grown person, I never wanted to hear. Because you know that it's going to take more than 40% of whatever you are earning. But it is a necessary evil. Something that if you don't have, you would have to get from another person. Because you are getting from another person. And also because of the fact that the person would want to protect his or her interests just like you would want to protect yours. It is always important to have an agreement. One, the agreement has to specifically state or describe the property that you are going to occupy or you are going for. Sometimes when we talk about rent, people always think that it is residential. You need a 2-bedroom apartment and all that. But some people rent for commercial purposes, for warehouse, some for studios. I hear Albert has a house. We would have to rent a room for our studio. Yes. So you would have to have a clear description of that property you are going in for. 2, how much are you paying for it? Because we have people, in the olden days, there was something called mortgage, where they were not writing them. And so he will come and then he will see that you really need the money. He say, okay, you put this house on as a security so that you pay. Because you need the money, even if he tells you that you are paying interest of 1,000 per day, you will take. And because you have not written it, 1 month later, he will come and tell you that the interest, he did not say 1,000, he said 10,000. Then it comes to a point where it is your word against mine. Very difficult. So we advise people, every rent agreement should state specifically what you are paying each month. If it is supposed to be paid yearly or quarterly in advance, state it. Those 2 are very important. 3, because you are different from the one who is giving the rent to you, or because you are different from the person you are giving your house to, the parties have to be described. I am coming for Davina's house. I become the tenant. You are the landlord. The names are supposed to be there. Define our rules or our designations. You are the landlord. I am the tenant. Before you even go on to the specific, what we call covenants, the specific obligations that each of you would have to undertake. These are very basic that nobody should compromise. But I have to say that the fact that you are going for a rent does not mean that even if it's 3 months, you are supposed to get an agreement. Because a written agreement ordinarily should be from 2 years. If it's 1 year, the person can say that, oh, we don't need to put it in writing. But of course, if I am that educated and I know that something can happen one day and it comes to your word against mine, even if it's 1 year, I would still want that agreement to be written. Yes.
Yeah, so to add on to what Prince just said, a lot of people ask, if I don't put my tenancy agreement in writing, is it enforceable? The simple answer is yes, it is enforceable. But like Prince said, where there's a dispute, it becomes your word against your landlord's word. Or in the case you are a landlord, I know that some landlords may be watching us right now. Yes, and it's not always that a landlord cheats a tenant. There might be instances where the tenants are the ones cheating the landlords. It happens, yes. So you don't necessarily need to put it in writing, but again, the elements of a tenancy agreement are a lot, and the agreement might be a bit complicated. You see, it takes time. There's something we say in Tree, an adage that nipa refi, you might forget some of the details, and there might be a contest or a dispute between you and your landlord or your tenant on those details. So it is advisable to put it in writing, but it is not a prerequisite for that agreement being enforceable for it to be in writing.
Yes.
And also, what Prince said, termination is also very important as to when the tenancy period would come to an end, and notices as well. And also concerning the signing thing, I think it's very essential. And also the landlord, especially the party against whom it will be enforced, must sign.
Okay.
You know, something just crossed my mind. Assuming there is this scenario where you've gone for a 1-bedroom apartment and it was purely oral. The person said you should pay 2 months rent as security deposit. It's not written. You don't even know what that security deposit means in his words. You know, ordinarily they take those things so that at the time you are moving out, if there are certain things you are supposed to fix, then they will use that one. Then the day you are leaving, he says that you have to paint the room. What would you do? Because one, you gave him the money, security deposit, you did not even ask what it was. When he says that it was part of the rent, what would you do? So
how do you fight something like that?
And Prince,
if
actually,
there's nothing
that's
written?
not far-fetched. Recently, we had an issue. The person who let out the property is now dead, and her sister is now the executor. She actually wrote a letter to the tenant that he should evict the premises, and also he should make some payments for maintenance and other thing. And the guy was saying that when the woman's sister was alive, he paid 2,200 as security deposit. So he's now not going to pay any money. The sister should use that money. And the executor was requiring for proof.
Was there any written? There was
They
nothing
actually
written.
did a written agreement.
Okay.
So that was what actually saved the guy.
You
So
see?
he didn't end up paying the security paying additional for maintenance and repairs. They ended up using the security deposit to offset any amount that he was. So
and you see, the
it's
opposite is
very
also true.
important.
There are situations where people go, they are let in and they have to paint the room before they can move in. And they'll be living and the landlord will be saying that you have to paint, and you say that there wasn't any agreement like that. You see, last week or so, I saw a news article where one of the officials of rent control was saying that tenants should humble themselves.
I saw that.
I am sure that something caused him to say that. Possibly they go there before rent magistrates. They go before rent managers. And you can see the level of arrogance that people exhibit. I've done it before. I went to rent control, and I was representing the tenant anyway. she had paid security deposit, and the landlord had given all the assurances that there is water, there is heater, there is that, nothing. But you see, the problem was that she had a discussion with him over the phone because she wasn't in Ghana. And she swallowed everything that's there.
Hook, line, and sinker.
Absolutely. So she came in the first day, water was flowing. That was it. Water was not flowing anymore. He called the landlord, and then the landlord said that he's not Ghana Water Company. You see? Then I asked her, where is your agreement? So fortunately, the agreement stated all those representations, that there's water, there's this, there's that. I wrote a letter, the way the man insulted me. I wrote a letter to him that this is what you represented to the tenant, and that is what induced her to come for your house. So if they are not there, that is a breach of contract.
Yeah.
We are amenable to you providing those things, but in the absence of that, can you give us the money back?
Okay.
And then she said, unless he gets another person
to come
come
and rent the property.
and take the property before. That's how come we went to the rent control. You see, so these things. Just imagine, even the situation where there was an agreement. This is what happened.
Yeah.
Just imagine
Yeah,
if you don't have an
makes sense.
agreement.
Okay. So in addition to having the agreement,
Yeah.
I'll advise that any receipt of payment is kept as proof of payments for the
Very
rent,
important.
security deposits, and everything to protect yourself. So our next area is about the obligations of the landlord and the tenant. As regards to Prince's example, what do you think should be the obligation of the landlord in a tenancy relationship?
So actually in Ghana, we've sought to make it easy for landlords and tenants. We are all aware that there is a Rent Act. It will interest our viewers to know that that Rent Act was passed in 1963. Yeah.
Where were you?
But this also brings up a related issue. There's something we say a lot in Ghana that has now attained anecdotal status. We say that we have good laws in Ghana, but then it is making sure those laws work.
Implementing
Implementing it,
nightmares.
that is the issue. Implementing it is the issue. Since 1963, the successive parliaments and governments we've had in Ghana have not felt the need to scrap that Rent Act and replace it with a new one till very recently. So it means that that Rent Act, for all intents and purposes, is effective for determining the responsibilities of the landlord and the tenant. Fast forward to recently, 2020, correct me if I'm wrong, we
around that
passed
time.
a new Land Act, a comprehensive Land
Yeah.
Act. That is supposed to encompass all things related to land tenure acquisition and rent matters in Ghana. Now, in that Land Act, which came to take over from the previous regime where we had different land acts, and in that new Land Act, certain covenants, I wanted to use the word responsibilities, but let me use a word that's actually used. Covenants have been put in that act that should be performed by both the landlord and the tenant. Do you understand? So parties might enter a tenancy agreement, and for simplicity's sake, they might agree that we want to adopt all those covenants that have been put in the Land Act for use for our agreement. You get it? And as part of those covenants, the tenant has a covenant to pay rent. I should think that's
the
most basic-
fundamental.
That's the fundamental one. The tenant needs to pay rent. But there are also other covenants that some people might have an inkling of, but they might not necessarily know. For instance, as a tenant, you need not use the premises that you've rented for any immoral or illegal purpose. And sometimes when you tell tenants this, they get up in arms about, hey, I'm paying for the place.
It's my room.
can
It's
I'm
my
occupying
room.
it. They are telling me what to do.
Exactly. So yes, there are quite a number of covenants on both the landlord side and the tenant side that can be adopted into tenancy agreements between landlords and tenants.
And also for the landlords especially, I think per what Prince said, you must ensure that the property is fit for purpose. You would
Yeah.
represent to the client or the tenant that, oh, there is water, there is this, there is that, only for the tenant to end up in the apartment and all these things. And you should also make sure that the tenant enjoys quiet.
I was waiting for it.
Very important, especially for those that their landlords are living in the same
See.
apartment. As at 12 a.m., maybe
Playing
music,
music.
loud
These
music.
two covenants you just said, there might be instances where it might be outside the hands of the landlord. For instance, let's say there's a church right next to the landlord's apartment, and the church runs services at odd times. You see, the landlord has the obligation to ensure that the apartment or the premises is fit for purpose, which is for human occupation. Incessant noise defeats that purpose. But in this instance, the landlord is not directly responsible for that.
So you see, those things that are outside your control, let's leave them to go. What about those that are within
But
your
they're
control?
affecting the tenant's occupation.
No, you see,
The tenant is uncomfortable.
you see, we have to. For me, I always narrow the scope of quiet enjoyment, right, to things within the control of the landlord. Some landlords, when you are supposed to pay rent on 30th, 29th,
So I start saying how?
Banging on your
you
door.
go and close the tap.
Yeah.
He will close the tap. It will not be
Serious?
flowing.
Yeah.
And
Or cut
and then
electricity
the next
flow.
day, he will close it around 6 p.m.
See, me Chawano, for our Gen Z viewers who might not know, the best depiction of this type of landlord is Santo of blessed memory. of the Pharisees. He comes early in the morning wearing his cloth, and then he's coming for his money.
You see, you can come for your money. It's yours, right?
Is it due?
29th, 6 p.m., he will close the tap so that when you call him to ask, he say, oh, and you're trying be a 30th.
But
That is
see,
the day
when it
he's
comes to
supposed
his
to.
rent.
When you call, you say, oh, now say me rent in the crowd, you see, so you have to pay. You see, that is an interference of quiet enjoyment. There are cases where a landlord claims that he was owed rent and he went to take out one of the windows. You see, that is interference. Even when you read the same, the Rent Act has not been repealed. Just that a portion of it have been included in the Land Act. But the Rent Act itself has not been repealed. It's still in force. When you look at Section 17, it gives you situations where you can interfere. Yeah. Even when the person is owing rent, the law says if the person has not paid the rent even 1 month after it fell due. So if I'm supposed to pay on 30th, you come to my house and I say come tomorrow, you can't come and take my window. Exactly. But that is what people are doing. It is the tap they are using. Some of them too will find those electricians and they will come and unscrew some things in your meter and then your lights will not be coming. Because you will not be in the house, you will not even suspect that is the
That's
meter.
what's going on.
You would think, oh, ECG, ABM. You will be in the house. And then you
Everybody
pay
has
rent,
lights.
the light will come.
Comes.
You see, so we have to let people understand. That is why, in some way, somehow, I had a problem with the statement of that head of rent control official, because when you in Ghana, a lot of people are headline readers. Yeah. They don't go into the details, so you have to explain. If you say that they are supposed to humble themselves, you give the landlord a lot of power. Exactly. About 2 weeks or 3 weeks ago, I went for a meeting concerning this thing. And then the lawyer for the landlord was like, Prince, see, we are the landlords, so you have to show us respect. I was like, boss, I am paying rent.
You see, it has become a systemic issue. It's cultural. You see, over time in Ghana, we've cultivated the environment that the landlord is always right.
Yeah.
The landlord does what he wants with his premises, and it shouldn't be so. It shouldn't be so. So I think that's the reason why the government has decided to also take a part in what goes on in this sector, you see, to ensure that tenants are not unlawfully taken advantage of by landlords.
It's even why the tenant is more protected under the Rent Act. Because when you read the Rent Act, you realize that most of the provisions are there to protect the tenants from the abuse of the landlord.
Exactly. I would like to pick your minds on something. As part of the tenant's covenant, not to use the premises for any immoral use. You see, immoral can be defined in many ways, depending on your faith. Or
Yeah.
So let's say I rent your premises and I believe in polygamy. So on different days, my wives come and go. As a landlord, can you kick me out for that? I would like to pick your minds on that.
You said your wives.
Oh,
So are you the tenant?
So I am the tenant.
Okay.
Yes.
For all intents and purposes, I came for the premises. But let's say on Monday and Tuesday, Abner comes. But Wednesday, Thursday, and Friday is Belinda's turn.
And Saturday and Sundays for who? Area 4.
No, but they are coming.
So in that instance, will a landlord be right to say that I am using the premises for an immoral purpose?
So you see, that's why I said you said your wives.
Exactly.
You see, tenancy or tenant-landlord relationship does not, let me say, metamorphose into familial relationship. You are not my abuser, Penny.
The use of the wives there was euphemistic.
So
you
just say
meant
you are
concubines.
bringing different girls.
So see, it's about what the landlord does. Don't focus on what the tenant is doing. I want to know, would the landlord be right to say that that's an immoral?
You see, there's also what we call freedom of contract, where at the beginning of your relationship, you put into writing things that you, the tenant, would be required to do and things that the landlord would be required to do. I have seen tenancy agreements that the landlord says that nobody should pound fufu on the compound. If you are a typical Asante who wants to eat fufu every day, your
Landlord will help.
on how you
that's
actually
no rent.
need fufu because the house is not yours,
Exactly.
right? The house is not yours. It is my house, my laws. I want this to happen in the house. Are you amenable to it? If you
not-
say fin, you have to abide. Just like you expect him not to come to your room on 27th to take rent when you are supposed to pay on 30th. You get it? But if in the absence of something like that, it will mean the person is restricting you to a point. A typical example is my wife's friend called me that the mother had been locked behind the gate. Why? The landlady said she greeted her and she didn't respond.
Hey,
But locking no.
what's this?
You see, that's different.
Abuse.
You see, that's different. But I have told you that in my house, I don't want different people I don't know to be entering
Coming
in each now and then. You see,
right.
it is not about what you do in your room, but the security of the place.
Some landlords might say it's for security purposes, but it's just envy.
Every because you have many girls. But in any case, if the landlord perceives it to be an immoral purpose, he can't just evict
So
you.
you see, he said if the landlord perceives, we don't have
Something to
A standard.
we don't have a standard. So what is immoral in this instance?
Freedom of contract. The two of you have sat down. Did he force you?
No.
Yes. The two of you have sat down to agree on the specific terms you want to govern your relationship as a tenant and a landlord. So if it is not in there, then you have a cause of action or you have a cause to complain. But if it's there, how can you tell me that you have gone to sign something that you knew that it will not be so okay for you, and now you come back to, that's what I call adanko dadadre. So you see that.
So that's where the writing.
I think,
That's where the
I
writing
think
is
in
important.
this case, maybe if the particular tenant is using the premises more like a brothel,
More like
or
a
some-
brothel, yes.
That one it can qualify
So
as
that
immoral,
clearly qualifies as immoral.
but your girlfriends coming in and going in, I don't. That's me personally.
No,
I
me in
don't-
my house, I will not allow it.
Oh, okay, but I don't see why. And
not allow it.
how would you even tell that it's the person's girlfriend? Why would you
It could
go
be
in
his
digging?
sisters.
Exactly.
Hey, see you
That-
people.
because
Or
the
his
fact that
cousins.
Amma comes today and Osia comes tomorrow doesn't necessarily.
You see, I can't say that. Adia openi. Ojina minemu a omehu. Akola jina bipo so kra Aha.
So yes, Davina, as part also of the obligations that the tenant has, there's one that a lot of tenants seem to overlook, which is they should reasonably allow the landlord to come into their premises to inspect from time to time. And where their premises adjoin other tenants, and there may be instances where to repair the premises of that adjoining tenant, the workman or the repairer needs to be given access to the tenant's premises. Yeah, as long as it's reasonable, as long as it's not at
I like the
odd hours.
reasonable.
But what is reasonable?
Yes.
Exactly. But 12
What do you
a.m. you
think?
can't come knocking.
Yeah.
Well, if it's an emergency
That's
situation,
different. But to
No,
inspect,
but how can a landlord just come to your house and say, I'm coming to
No.
inspect?
Yeah.
And
You
the
should
landlord
give
also has to give
notice.
notice.
Exactly.
Yeah.
That's why I have been referring to freedom of contract. All these things are supposed to be taken into consideration. This repair thing that you are talking about, you know that one of the covenants will be not to alter the premises without the
Without
consent.
consent.
Yes.
You know, the Gen Zs who have come now don't like the walls like that. They always want to decorate, you see, with different wallpapers. And you see, the wallpapers will always, affect the wall when you peel them off.
Yeah.
A landlord who doesn't want it will tell you that, no, I don't want you to do it. You see, you don't own the property. You have an interest. The interest is very specific. Occupation for a specific period. So, because of your 2 years, I should deteriorate my walls.
To my detriment.
No, it will not
It's
happen.
not fair.
So, things that you don't understand, ask, get clarity. Now, take it as something you have understood to be bound by before you move in. You get it? When I was going to law school, I was moving around with a friend to get accommodation. Then we went to somewhere, Medina, they called the place Libya Cortes or something like that. And then we met this landlord. He sat us down and said that his house, he wants the place to be clean every day. He has only one tenant there. So the two of us coming, there will be 3. So me, I will sweep on Monday, Tuesday. My friend will sweep on Wednesday, Thursday. And the lady there will sweep Friday, Saturday, and Sunday. Me, I don't want to sweep. So I left. Did I die? No. You get it? We have to understand these things. Yeah.
Okay. So, pertaining to Albert's question and how Prince said if he was a landlord, he won't allow you to be having multiple
At
girlfriends.
all.
So, if you're a tenant and you have multiple girlfriends and your landlord is upset about that, can he just evict you from the premises? Basically, because he thinks your use of the premises is immoral.
So when it comes to eviction, a lot of the time, what happens is that landlords go about it arbitrarily, which shouldn't be so. The Rent Act actually makes certain provisions, and I think the most paramount of that is eviction must be done pursuant to an order of a magistrate or a court. even the rent control officers cannot assist the landlord to evict a tenant.
Yeah.
So what's supposed to happen is the landlord needs to give the tenant notice of whatever it is that the tenant is doing. So in this instance, it's an immoral act or an illegal act. Whatever it is that the tenant has done, that the landlord considers to be a breach of the tenant's covenants under the agreement, the landlord needs to make the tenants aware
Yes.
of such things and also bring them to the notice of whatever the magistrate of the area where they stay, who will be adjudicating the eviction matter. Yes. So the landlord cannot just get up and evict a tenant, but that's not what we see.
Yeah.
Yeah, landlords tend to do what they want,
Even
which
with that-
shouldn't be the case.
Even with that on the breach of the tenant's obligation, in order for the landlord to be able to acquire an order to re-enter the premises, it should be in the written agreement that where the tenant breaches his obligation, the landlord will have the right of re-entry pursuant to an order of the courts. Yeah.
Yeah.
And also with the immoral issue, it's not necessarily the tenant too. Someone residing with the tenant as
Exactly.
well. So mostly we tend to think, oh, if it's the tenant. But let's say Albert is living with his sister.
Or
and
his
it's
girlfriend.
Not, exactly. And
It's
it's
still
not
you.
Albert who is exactly engaged in that act, and it's Albert's sister. The landlord can still.
You allow the person to come in, so it's
Exactly.
still you. So, like I said, Section 17, I think everybody who rents or who has apartments to rent should get to read. Section 17.
To that, I would also
Of
add
the Rent Act.
I would also add Section 51 of the Lands Act,
Yes.
Act 1036. And then 51 takes you to Part 5 of the second schedule. So 51 basically provides that there are certain covenants for tenants and landlords. And then when you go to Part 5 of the second schedule, it lists out all those covenants for easy access. Yeah.
And even in addition to the immoral or illegal purpose, there's another manner in which the courts may evict a tenant. That's where the tenant has been convicted of engaged in an act which has an immoral purpose or an illegal purpose. So it's either the immoral act falls within the covenant of the tenant and he has breached it. That way the landlord can acquire an order from the courts, or the tenant has been convicted of engaging in an immoral purpose.
Yeah.
Yeah. And most times, landlords use non-payment of rent as the ground, yes, as the ground for which
Yeah.
they are evicting. And even for that, it's not a cut and dry matter that as immediately the tenant defaults on rent, you, the landlord, can go in and then get the tenant out. There is a procedure to it. There's a process to it. And certain timelines must be followed before a tenant can be evicted for non-payment of rent.
This rent issue that you are talking about, our laws are very clear as to how many months you can collect as rent advance.
Yes.
I think 6 months.
Yeah.
Yes, 6 months.
Huh. But you see, the problem is looking at the market. We have a liberal market where the market forces determine how they want
The
to.
state doesn't manage how people
Yes.
conduct their private business.
I have my house, and I'm saying that I would accept at least 1 year rent advance. If you come and you say that the law says 6 months, go to the law and go and take your house. You see,
Even lawyers
And
are
that's what always
normalizing
happens.
this.
Yeah.
yes,
That's what always happens.
because due to that, people cannot even go to the rent control to go and complain.
Yeah.
Because
It's the market forces.
yes, because you go, you say, okay, it's okay. I will not take the 6 months. This is my house. There's no law that says that if I'm not giving my house to you, I should go to
They
jail.
compelled us.
So, bye-bye. You see, but another angle to it is that, like I said, you can do this adankudadadwe to one of these, the landlords. The first year, he will pay the 1 year and be there. When it is due and you come and you say you want 1 year rent advance, you see that the law says 6 months. If you are fighting him, at the point he is a statutory tenant.
Yes.
So the only means I'm not teaching people.
I did watch you. I'm not teaching.
At the point is a statutory tenant, and the only means you can take the person out will be proving that the person has not paid rent at least 1 month after it fell due,
yes.
and then something else, which is maybe you require the room for commercial purpose for your own occupation, or maybe your cousin or your family B is coming.
Yes.
So you see, the threshold is that
It's high.
high.
And even when it comes to landlords adjusting rent prices, if you look at the Rents Act, a landlord cannot just get up and adjust rent.
Yeah.
You see,
Actually, an officer of the rents,
control department.
yes,
And you must even give notice to the
exactly.
as to
An
their
officer is
rent.
supposed to come and do an assessment of the premises.
in this
Look
Ghana,
at the nature of the premise. No, it's what should be done. You see,
Yeah.
that's why I said at the beginning that we have good laws, but then when
the
it comes to
implementation-
implementing it
No,
and then
Albert.
enforcing it, it becomes an issue.
Albert,
A landlord shouldn't charge rent arbitrarily. You get up today, Ghana Eden.
Albert.
Rent, oh.
I have a
Albert.
friend
Matum.
who wants to lease as Kaswa. It's a 1-bedroom apartment and it's 3,000 cedis a month.
You see,
Wow.
in this
Imagine,
instance,
as Kaswa 3,000.
if a rent control officer was the one doing the assessment, that person takes into consideration
The
the
value,
locality,
the locality,
exactly,
the
the peace of mind that the
Albert,
tenant is going to,
Albert.
the security.
Yes.
All this
I
hasn't
will
been done.
not.
3,000
I
was
will not.
excessive.
I will never agree with you that this is a good law. You see,
No.
Why?
I think that Ghana, as far as rent, laws concerning landlord and tenant are concerned, we are backward. You see, there's a historical antecedent to it. The 1963, when that particular law was enacted, at the time you ask yourself how many real estate developers were in Ghana. Who was president? It was Nkrumah. Nkrumah has this socialist
He had, yes,
Yeah.
paternalistic
ideas
Yeah.
where he wanted everything to be controlled by the government. So you get a rent control officer to come and do the assessment. Today, Ghana, you are calling someone to come and assess my house.
So then over the years, it makes you realize that governments have failed the populace, successive governments. Let's say Saglemi was up and running and we had a number of them spread across the country. Landlords won't have the power that they do now. Do you get it? So we probably started from a point where it was necessary for the state to determine the relationship, the rules that guide the relationship between landlords and tenants. But then it shouldn't have been something that should persist over 50 years down the line. You see, over time, there should have been, and the state should have identified a gap in delivery of accommodation,
You see, they have.
and then plugged that gap.
You see, the gaps have been identified. When you read the rent bill, which is still pending, when you read it carefully, you come to understand that someone has gone through the system and identified problems,
The issues.
but the problem is that they have not passed it. You see, there are people who are benefiting from the current system and they don't want the status quo to change. It will never change. It's just like me. If I'm a poultry farmer right now, the best advocacy I would do is to plead with the government that they should stop the importation of frozen chicken.
Now, why did you man say?
So if the minister responsible for trade herself or himself or her cronies are importing chicken, they will come and say, oh, this is a very nice idea, we'll consider it. And then they'll give you the political line. It is in the pipeline. The pipe will never burst for you to see it. You see, that is what we are facing. And I think that, rent is choking people.
Yeah.
And it's not because people don't have money to rent.
There's more supply. There's more demand than there is supply.
And they are cheating people.
There's more demand.
For want of a better word. They are killing us. You see, my voice has even changed.
Before we go, I'd just like to put this out there. So there was an instance where a tenant who rented a story building was pounding fufu on his floor, and he was held to be causing a nuisance,
Is
to
it
causing a
Dennis
disturbance
I
too.
can tell you?
Yes. I don't want to mention the names.
Right.
Yeah, basically, it's to put this out there to potential tenants. A landlord can eject you. Of course, the ejection will be according to certain rules, but a landlord can eject you for pounding fufu on the top floor of his
Disturbing
property.
the-
So beware.
The quiet enjoyment of other persons.
Exactly.
The fact that you are hungry does not mean people will
I think
not.
the fact that it's a story building and you pounding for
Yeah, it can be dangerous.
Yeah.
So beware. Yeah,
This has been an exciting discussion. Obviously, we have more matters to discuss, but that will be done in another part. Thank
Yeah.
you for your attention and have a lovely day.